Hi, and welcome to the first of two videos that will provide training at Dental Masters for HIPAA. This video covers the history of HIPAA and HITECH and how it applies to healthcare practices around our country.
HIPAA stands for the Health Insurance Portability and Accountability Act. It was enacted in 1996 and required that all covered entities be in compliance with the electronic transaction rule by October of 2002 and with the health information privacy rules by April of 2003. It is administered by the Department of Health and Human Services for the United States of America. When Congress enacted HIPAA in 1996, it was originally designed to make health insurance portable. For instance, if an individual were to move, they could take their existing health insurance policy with them. Limits on how much an insurance company could raise premiums in these situations were also governed and capped. For most covered entities, compliance was required by 2002 for the electronic rule and by 2003 for the health information privacy rules. We have been living with HIPAA rules for a long time now. The original HIPAA Act also included a series of administrative simplification provisions that require the Department of Health and Human Services to adopt national standards for electronic health care transactions. This was about the time offices were beginning to use electronic claims, the internet, and email. Uniformity and simplicity needed to be established with regards to patient health information, especially as it was being used over the internet waves. HIPAA was also created to require security and privacy standards to secure an individual's protected health information. With these regulations in mind, the following is a list of those rules and their status as the fourth quarter of 2001. The Electronic Healthcare Transaction Final Rule, the Healthcare Privacy Final Rule, Security Requirements, Unique Identifiers for Employers, Unique Identifiers for Providers, Unique Identifiers for Health Plans, and the Enforcement Procedures. As you can see, HIPAA rules were still evolving. Rules continued to change as the government got feedback from the industry. One of the main objectives of the privacy rule is to help ensure fair and equal health care. Privacy will help everyone attain fair insurance coverage and to avoid discrimination in other areas of their lives. In addition, protecting the privacy of patient health records is an ethical obligation for two reasons: because of the delicate private nature of many disease states, because patient health identifiers can lead to identity fraud, which now plagues this country. With the implementation of uniform guidelines, congressional researchers concluded that billions of dollars will be saved each year for healthcare businesses by lowering the cost of developing and maintaining software and reducing the time and expense needed to handle healthcare transactions. This sounded reasonable, but as time and technology change, HIPAA laws may evolve to become more robust and may actually demand the development or additional software, manpower, money investment, and time. Still, we will comply. Furthermore, HIPAA was also created to require security and privacy. The HIPAA privacy rule enactment started on April 14th of 2003 and was the most influential step in HIPAA and in the protection of health information privacy rights ever undertaken in this country. Healthcare providers now are required to comply with keeping patient medical information private, and the term covered entity was developed to ensure that protected health information or any health information that identified an individual within the setting of a treatment facility was only used for treatment, payment, or administrative purposes within a healthcare office. These offices and practices were required to provide paperwork acknowledging these rights and have patients sign forms indicating they understood the details of both a practice's use of PHI and a patient's right to assess that information. On October 17th of 2003, the transaction and code set standards were issued to cover any medical information, written, spoken, or in electronic form. As you can see with HIPAA at the center, We do have the privacy rule, the security rule, the enforcement rule, the unique identifiers rule, and the transactions and code sets rule. So let's take a journey through the timeline of HIPAA, HITECH, and the final omnibus rule. As previously discussed, in 1996, the Health Insurance Portability and Accountability Act was brought and enacted in Congress, and it took into consideration the technology boom and patient information becoming exposed. In 2003, the rule was enacted and covered entity became a term for all healthcare providers. These small healthcare providers were now required to comply with keeping patient medical information private. In 2005, the security rule was enacted on April 21st, and it was oriented exclusively around the electronic maintenance, storage, and transfer of PHI. The security rule goes beyond the privacy rule in its protection against any reasonably anticipated threats or hazards in the security and integrity of the information that was defined to be protected under the privacy rule. Healthcare offices needed to be conscientious of keeping private any medical or identifying information from accessibility by those not necessarily needing that information to continue proper treatment and administrative of healthcare offices. 2009 brought greater HIPAA enforcement with the HITECH Act. After the election of President Barack Obama in 2008, the American Recovery and Reinvestment Act of 2009 had in it significant provisions for the increased enforcement of both the privacy and the security rule. Most of the important changes to HIPAA are contained in the HITECH Act, which is part of the ARRA, and it became law in February of 2009. Breaches of confidentiality of information, how to avoid them, and how to handle them once detected became the primary focus of the HITECH rules. The fast and furious nature of the changes has become evident since that time. The year 2010 brought another government agency into the realm of HIPAA. The Federal Trade Commission became involved in the evolution of the privacy law as it affects healthcare providers in the enactment of the so-called red flag rules. They are designed as an anti-fraud set of regulations for creditors to recognize and detect the possibility of identity theft among their patients. A great number of scenarios and signs of red flags, such as theft, might be occurring and were laid out by the FTC and now must be recognized by all office staff and healthcare providers that allow patients to pay not just upfront for services, but over time or with payments by third parties. This law, as of now, has not passed as a federal standard, though it is highly recommended that every healthcare facility have an anti-fraud policy in place to avoid monetary loss. The red flag rules requires a four-step process for compliance: to identify the red flags, to detect the red flags, to prevent and mitigate identity theft, and to update the program and practice uses to prevent further or future attacks. Relevant red flags to dental practices would be a patient presenting with a fake ID, an ID that appears to be altered, no ID at all, no proof of address, a signature that does not match the one on their identification, a social security number or employee ID number that doesn't match, if a patient refuses to take a photo, forms that might be completed with mismatched information, if a patient can't answer personal information without checking their identification, if they leave important parts of a form blank, if they want to change their information not long after it's been given, if there are repeated changes in credit card information, or a bank or credit card company sends unauthorized use notices. These are relevant red flags that every dental office must be aware of and keep in mind when it comes to the red flag rules. 2011 brought us the HITECH law. It requires healthcare facilities to have a written protocol in place regarding how PHI integrates with their technology. Written and required federal laws for all healthcare offices. HITECH mandates that this protocol be in place and trained upon. Internet interface with routers and firewalls, telephone messaging security, internal computer terminal password protection, and paper shredding are among the mandates. All employees have to sign a training document stating that they understand that they can be held personally responsible for any malicious conduct, either verbally or posted on the internet or electronically.
2013 brought us the final omnibus rule. This rule is the last one that has been enacted regarding HIPAA and HITECH to date.
The 2013 Omnibus Rule is really just a composite of four closely related rules: the Privacy Rule, the Security Rule, the Breach Notification Rule, and the HIPAA Enforcement Rule. The biggest change, however, is that now anyone who touches PHI must be in compliance. Covered entities, business associates, as well as subcontractors. The Omnibus Rule, or the Final Rule, is a 563-page revision to existing HIPAA law that updates and changes many aspects of how we handle PHI, patient requests for PHI, marketing, and product service dispensing or referring. Omnibus Rule creates a further reaching matrix to protect PHI. This will include holding business associates responsible for the confidentiality of PHI use and disclosures to their subcontractors, plus accountability to report breaches of PHI. All entities will follow a four-factor assessment protocol to evaluate potential breaches, and documentation and reporting protocols must also be established within the business dwelling. Other patient notifications are also included in the Omnibus Rule, and they include but are not limited to the use and disclosure of PHI in marketing fundraising, opt-out options, third-party disclosures, insurance notifications for out-of-pocket paid in full treatment, as well as many other protocols. The two most important parts of the Omnibus Rule, however, have to do with the Notice of Privacy Practices and the Business Associate Agreements. As you can see here, the Privacy Practices portion creates specific amendments to include those related to breach notification to health plans, marketing, fundraising, and the new privacy practice must include the date it is first in effect, be posted in the practice, be available on paper to any patient and anyone who requests it, and it also must be posted on the practice's website. For the business associate agreements, a practice must review its relationship with each of its vendors not currently recognized as a business associate to identify if that vendor meets the expanded definition. The business associates are independently responsible to the OCR to comply with HIPAA privacy, security, and breach notification rules and are subject to OCR levied fines. Practices are no longer responsible for HIPAA infractions committed by their agent BAs. Furthermore, the BAs are responsible for the violations committed by their subcontractors. They must comply with the security and breach notification rule that the practice is liable for the actions of BAs who are agents, but not for those of their subcontractors. With regards to the HIPAA breach notification rule, it requires the covered entities to notify patients when their unsecured protected health information is impermissibly used or disclosed or breached in a way that compromises the privacy and security of the PHI. An impermissible use or disclosure is presumed to be a breach unless the covered entity demonstrates that there is low probability that the PHI has been compromised. Once again, we must use a four-factor test. The first part is the nature and extent of the PHI involved, including the types of identifiers and the likelihood of re-identification. For instance, a social security number and a zip code are not the same level of breach. The second part is the unauthorized person or people who use the PHI or to whom the disclosure was made someone or some entity that will potentially do harm? Was the PHI actually acquired or viewed? And what was the extent to which the risk to the PHI has been mitigated? That's the four-factor test that is required under HIPAA's breach notification rule. The HIPAA enforcement rule contains provisions relating to compliance and investigations, the imposition of civil money penalties for violations of the HIPAA administrative simplification rules, and procedures for hearings and appeals where the covered entity challenges a violation determination. The Department of Health and Human Services has compiled, in order of frequency, a list of the top 5 complaints that are waged regarding HIPAA violations with healthcare practices. They are first, the impermissible uses and disclosures of protected health information. Second, lack of safeguards of protected health information. Third, lack of patient access to their protected health information. Fourth, a lack of administrative safeguards of electronic protected health information. And finally, use or disclosure of more than the minimum necessary protected health information. As you can see, we must always be aware of these situations and do our best to remain in compliance when protecting our patients' health information.
So as I stated before, there haven't been any significant changes to any rules regarding HIPAA or HITECH since that omnibus rule of 2013. One of the biggest questions that comes my way is how often should we be training on HIPAA? The fact of the matter is the Department of Health and Human Services never stipulates how often an employee or a practice must train on HIPAA. They only say that every employee who works for a covered entity or a business associate and that might handle protected health information or electronic protected health information or come across it must be made aware of the regulations, safeguards, how to properly handle the data, as well as their personal liability should they cause or create a breach. It requires that we provide additional training if we feel an employee needs to be remediated, if we think that they may be exposing PHI or potentially exposing PHI. And we also know that we must make every employee aware should another change to a rule be enacted. Beyond that, there is no mandate for how often anyone should be trained in HIPAA. We will keep these videos available for all employees at all times in case you would like to update yourself on it. Furthermore, it's very important at this point to really drive home the point that Dental Masters takes very seriously how we handle patient information. If you have created a breach or you think you might have or you may have seen one, it's imperative for you to let the doctor that you're working with in that practice know so that the proper steps can be taken to mitigate any potential breach and notify the proper authorities or the rest of the practice. Thank you so much for your time.